Evening to all the viewers. Myself, Dr. Rajesh Singh, Associate Professor, Parul Institute of Law, Parul University. First of all, I warm welcome Advocate on record Rajiv Kumar. Actually, sir, our Dean sir is right now joining in 1 minute. Yes, so he has joined. So first of all, I warm welcome Advocate Rajiv Kumar, Advocate on record from the Supreme Court, and as per the profile of Advocate Rajiv Kumar, he has a having vast experience of 11 years practice in the Supreme Court of India and has argued in various matters like the bail application, civil matters, as well as in the tribunal. He has argued in various matters. So, not wasting more times, the topic of this webinar is the jurisdiction of the Supreme Court. So now I will tell Dr. Akhil Sayyed sir, who is the Dean and Director at Parul Institute of Law, Parul University, to warm welcome our speaker, Advocate Rajiv Kumar. Dr. Akhil Sayyed sir.
Thank you, Dr. Rajesh. Thank you very much. And I am very much happy to cordially welcome Mr. Rajiv Singh, a learned advocate of Supreme Court. And I feel privileged between sitting between two Singh, uh, and that too the Singham of law fraternity, one in academics and the other in the field of practice. So it gives me a great pleasure. I know Mr. Rajiv Singh for with two two generations, and I know that um, law and justice is in his blood. So I am sure today's session is going to be a fantastic session. Uh, Mr. Rajiv Singh, I, on my personal behalf, on behalf of Parul Institute of Law and Faculty of Law, welcome you. And knowing that you are based in basically Vadodara, so I request you to kindly come down to the university with your physical presence as and when is convenient to your good self to enlighten our student in person also. Thank you very much.
So
Grateful, respected.
now handing the session to Advocate Rajiv Kumar to start this session. Now this sir, the session is handing to you, sir.
Respected Dr. Akhil Sayyed sir, Dean and Director of the Law Faculty, Parallel Institute, Vadodara, and for giving me this opportunity to speak on this subject, jurisdiction of Honorable Supreme Court of India. And I am also thankful to Dr. Rajesh Singh, who has invited me for this webinar. Now, I will start with respect to the jurisdiction of the Supreme Court. According to me, there are 8 jurisdiction of Supreme Court. First is original jurisdiction. Second is appellate jurisdiction. Third is advisory jurisdiction. Fourth one is discretionary jurisdiction. Fifth is contempt jurisdiction. Sixth is reference jurisdiction. Seventh is review jurisdiction. And last but not the least is curative jurisdiction. Now, I will start with first one, that is original jurisdiction. What is original jurisdiction of the Supreme Court? Now, Article 32, as we know, which is parameterial to Article 2 to 6 under Indian Constitution for the High Courts. Under Article 32 of the Constitution of India, now, if there is a breach of any fundamental rights, then you can file a writ petition under Article 32 before Honorable Supreme Court of India. As we all know, as we studies in our syllabus also, when we are as a student, that there are 5 types of writs. First is habeas corpus. Second is mandamus, writ of mandamus. Third is writ of certiorari, and writ of prohibition, writ of quo warranto. Now, what is habeas corpus? What is writ of habeas corpus? Habeas corpus means to produce the body, to produce the corpus. If any person is detained illegally by any private party or by the state under Article 12, then in that circumstances, a person can file writ petition before Honorable Supreme Court of India, but it is advisable to file before High Court under Article 2 to 6. In rare circumstances, you can file before Honorable Supreme Court of India. Now, as there is a leading case of Rudal Shah versus State of Bihar. The person was acquitted and he was behind bar for almost 14 years after the acquittal also. When it was highlighted in media, PIL was filed before the Honorable Supreme Court of India. In that case, compensation, Honorable Supreme Court of India, when it was filed, the person was released, Rudal Shah was released, and subsequently what happened, the Honorable Supreme Court of India awarded rupees 30,000 as compensation to the Rudal Shah. Now, second is mandamus, the writ of mandamus. What is mandamus? Mandamus means a command. It may be a positive command or it may be a negative command. Now, positive command means court will give direction to do something. What is negative command? Is to not to do something. That is writ of mandamus. For example, state is terminating an employee. If it files a writ and the court orders not to terminate the person, this is a negative command. So there are two types of command. Now similarly, writ of certiorari and writ of prohibition. Now superior courts like High Court and Supreme Court is giving direction to the lower court if it exceeded jurisdiction or a tribunal, and if it exceeds jurisdiction or pass any order, then order can be set aside by the superior courts, that is High Court or Honorable Supreme Court of India. Now, what is writ of prohibition? What is writ of prohibition? Prohibition means to prevent the inferior courts. The High Court or Supreme Court will prevent the lower court not to do something. Means, for example, if a learned magistrate is trying a case which is not under his jurisdiction. Now, in that circumstances, what will happen? If any writ of prohibition is filed, for example, if a case is involved in which IPC section 302 and magistrate is trying the case which is not permissible under law under the law, in that case he has to commit the case under section 209 of CRPC to the sessions court, and if he is trying the case himself, then the higher courts can prohibit that court not to try the case because it is not under your jurisdiction as per the CRPC. And last but not the least writ is quo warranto. By what authority? It is challenging the authority of a person. So therefore, there are 5 types of writ. Now, when the writ can be filed, that is very important. Writ can be filed against a state under Article 12. Only a writ of habeas corpus can be filed against any private person. If that person has illegally detained any other person, then only writ is maintainable. So writ is maintainable against state defined under Article 12 of the Indian Constitution of India. Only one writ, that is habeas corpus, you can file against the private person also. Now, in the original jurisdiction, there is a article in the Indian Constitution, that is Article 139A, where Supreme Court have the power to transfer certain cases. 139A. Similarly, we are filing petitions. Similarly, provisions are there in CPC as well as CRPC. Under CPC, Section 25 of CPC, the power of transfer the case from one state to another state of a civil nature. Civil nature means if a suit is filed, divorce petition filed by the husband for example, it is filed in Gujarat at Vadodara. Now, wife resides at Delhi. Now, because of difficulty, wife can seek a transfer of that divorce case from Vadodara to Delhi by filing a case before Honorable Supreme Court of India under Section 25 of CPC, stating that I have difficulty of going to attend the case before the Vadodara court. Therefore, in the light, Supreme Court may transfer that case, looking into the peculiar fact of each case. Supreme Court decide, the Honorable Supreme Court will decide accordingly. Now, similarly, there is a provision under CRPC where criminal case can be transferred, that is Section 406 of CRPC. Now, if a person wants that any criminal case laws against him, he can file a case which he want a transfer from one state to another state. Then he can apply a transfer petition, that transfer petition criminal, before Honorable Supreme Court of India under Section 406. There is a clear provision, and you can, if court thinks it fits proper, then court may transfer the case accordingly. Now, in original jurisdiction, one thing is more, that so far as if there is under Article 131, you may see that if there is any dispute between center and one state on one side or one more state on other side, if there is a state of two states on one side or two states on other side, if there is an interstate dispute between center and the state, or two states on one side and two states on the other side, then there is an original jurisdiction under Article 131 to file a case before Honorable Supreme Court of India. Now, in the original jurisdiction, there is another jurisdiction, that is, if there is any challenge to the election of president or vice president under Article 71 of the Indian Constitution of India, if there is any dispute with respect to election of Honorable President or Honorable Vice President, then it can be directly filed before the Honorable Supreme Court of India under Article 71. You can challenge that any person aggrieved or any person who is interested to challenge that, it can be challenged under Article 131 under Article 71 of the Constitution of India. This is all about original jurisdiction of the Supreme Court. Now, let us come on second jurisdiction, that is appellate jurisdiction of the Honorable Supreme Court of India. Now, under appellate jurisdiction, under Article 132, under which says an appeal can be filed against the judgment of the High Court if the High Court certifies that the case involves the substantial question of law that requires interpretation of the Constitution. Then in that circumstances, the appeal before the Honorable Supreme Court of India can be filed. Now, similarly, in civil matter, under Article 133 of the Indian Constitution, if the High Court certifies and if there and gives a certificate that the case involves a substantial question of law of general importance, that is very important, of general importance, then in that circumstances, the appeal can be filed before the Honorable Supreme Court of India. Similarly, in criminal cases, under Article 134 of the Constitution of India, which says that Supreme Court can hear the appeal against the judgment of the against the judgment of the High Court, if the High Court in the appeal reverse the order of acquittal, that is very important, order of acquittal, and sentence him to death, or has taken the case before itself, means the High Court is trying the case itself, means the entire trial is tried by the Honorable High Court, then in that case the appeal will directly lie to Honorable Supreme Court of India, and the High Court also in such cases certifies that it is a fit case of appeal. Then in that circumstances also you can file an appeal before Honorable Supreme Court of India. Now, so far as Consumer Protection Act 2019, now under Section 67, that provides an appeal to Supreme Court from any order passed by the National Commission, under any appeal under Section 51, or any order passed in the complaint under Section 58. Then in Consumer Protection Act 2019 new act, that in that case also you can come in an appeal for the Honorable Supreme Court of India. There are different acts where we see that you can come directly to Honorable Supreme Court of India by filing an appeal. There are different provision under different acts. For example, Section 30 of Armed Post Tribunal Act, you can file an appeal before Honorable Supreme Court of India. Similarly, against the order of NCLAT, an appeal can be filed within 60 days before the Honorable Supreme Court of India. Now, very interestingly, Section 379 of CRPC, read with Section 2 of Supreme Court Enlargement and Appellate Jurisdiction Act 1970, in which in the cases, for example, High Court in the appeal reverse an order of acquittal of an accused person and sentence him to death or to imprisonment for life or to imprisonment for a period for not less than 10 years. In that cases, directly an appeal will lie to before the Honorable Supreme Court of India. Similarly, there is a provision under Section 130E of Custom Act 1962, which provides for an appeal to Honorable Supreme Court of India from any judgment of the High Court on a reference made under Section 130 or any case which the High Court certified to be fit one for appeal to the Honorable Supreme Court of India. Similarly, in Central Excise and Salt Act, there is a provision, Section 35L, where you can file an appeal if a person is aggrieved by that order. There is a provision on appeal. Similarly, in the Contempt of Court Act 1971, specific provision 19(1)(b), by which if a person wants to file an appeal against that order, then he can file appeal before the Honorable Supreme Court of India. Now, in Advocates Act, there is a provision, Section 38 of the Advocates Act, which provide for an appeal to the Supreme Court against any order made by the disciplinary committee of the disciplinary committee of the Bar Council of India, and under Section 36 of Disciplinary Power of Bar Council of India or Section 37, then against that order you can come and appeal before the Honorable Supreme Court of India. But in different acts, the limitation period varies. Like in Section 38, there is a limitation of 60 days. Limitation is very important. Different statutes provides different limitation period. So we have to, as an advocate, we have to keep in mind that whenever we are filing any statutory appeal before the Honorable Supreme Court or to any other court where there is a provision of appeal, then we have to keep in mind, then we have to come within limitation. That is very important. If you not come within limitation, then you have to move an application for condonation of delay, and giving the reason. Day-to-day delay has to be explained from why after the expiry of the limitation period, why the petition was filed. You have to explain the delay as date wise. Now, under Section 55 also of Monopolies and Restricted Trade Practice 1969, there is a provision of appeal before Supreme Court of India. Similarly, Section 18 of Telecom Regulatory Authority of India Act 1997. Similarly, Section 15Z of Security and Exchange Board of India Act 1992. So there are different provision under different acts where you can file an appeal. Like I have already said that against the order, that is sections against the order of NCLAT, there is a new Insolvency and Bankruptcy Code. You can file under Section 62. If there is you are aggrieved by any order, you can file an appeal before the Honorable Supreme Court of India. Now, this is all about the second jurisdiction, that is appellate jurisdiction. Now, third jurisdiction is advisory jurisdiction, where the Constitution authorized the President
to seek the opinion of the Supreme Court on any question of law, that is very important, or fact of public importance which has arisen or which is likely to be arise, that is very important, or any dispute arising out of any pre-constitutional treaty, agreement, covenant, or engagement, or sanad, or any other similar institution, then the Honorable President can seek advice under Article 143 of the Indian Constitution, seek an opinion from the Honorable Supreme Court of India. Now, the fourth jurisdiction is discretionary jurisdiction. That is very important. We are daily filing the cases under Article 136 of the Indian Constitution. We say special leave petition here in Honorable while filing in special leave petition, civil or criminal. The beauty of this article is that you can challenge any order before Honorable Supreme Court of India. You are seeking leave to appeal before Supreme Court of India, but you have to establish why you are not going to the courts if there is any statutory provision, why you are directly coming under Article 136 by challenging any order. Generally, people are coming after High Court dismisses their petitions, either in civil cases after second in civil cases like second appeal, or any other cases. In after also we see that bail is rejected by the Honorable High Court, then directly special leave petition is filed before Honorable Supreme Court of India. Therefore, when there is no provision of appeal, then we people are filing, we people are advising if there is a suitable case. So then we people are advising to file a special leave petition before the Honorable Supreme Court of India under Article 136. This is a discretionary jurisdiction of the Supreme Court. Supreme Court having its own discretion. Now, under this, I want to quote a case of Kunai Ahmed and other versus State of Kerala, where doctrine of merger has been explained. What is doctrine of merger? When, for example, we are challenging the order of Honorable High Court before the Supreme Court. If it is dismissed in limine, this is practical aspect what I have understood and I am sharing with you. If it is dismissed in limine, then doctrine of merger will not apply. But if leave is granted, if any order has been passed after granting leave, then doctrine of High Court order will merge in Honorable Supreme Court of India and Supreme Court order will be final. So therefore, doctrine of merger is very important in this. Now, this is the fourth jurisdiction. What we have already we have covered four jurisdiction. Now, fifth jurisdiction, that is contempt jurisdiction. So, Supreme Court has been vested with a power under Article 129. Under Article 129, the Supreme Court of India having its power to punish for contempt of itself. Any person can be punished by the Honorable. So, Supreme Court is the only court having its own power of contempt under Article 129. Therefore, Supreme Court can do contempt, having the power as provided in the Indian Constitution under Article 129. That is, if Supreme Court thinks it fit, then Supreme Court can issue suo motu contempt itself. Secondly, then on a petition made by Attorney General of India, Learned Attorney General of India, or Learned Solicitor General of India, then in that case also contempt petition can be filed. Or on a petition made by a person, that is very important. Or on a petition made by a person in case of criminal contempt with the consent, that is very prerequisite, consent in writing from Attorney General, Learned Attorney General of India or Learned Solicitor General of India. If that consent is given, then only that petition can be entertained, otherwise not. we are seeing daily that in number of cases, consent is being asked when the petition are filed, and we are seeing that sometimes consent are declined and sometimes consents are given. It depends upon fact of the case. It depends upon the what learned Attorney General of India or Solicitor General of India think of a particular case. Then if they give consent, then definitely the petition will go on under the content here in the content. Now, the fifth jurisdiction is over. Now, sixth jurisdiction is the reference jurisdiction. What is reference jurisdiction? It is similar to like advisory, but the president can take can refer a case under Article 143(1) and 2. Similarly, under Article 317 of the Indian Constitution, when there is a question of removal or suspension of a member of a member of a public service commission or reference made by President of India, then in that circumstances, reference can be made to Supreme Court of India, and Supreme Court of India, the Honorable Supreme Court of India will decide accordingly. This is a reference duty. There are a number of sections where reference can be made. Like Section 11 of Competition Act, where the central government can make reference to the Honorable Supreme Court of India. So similarly, 14(1) of the Right to Information Act, 17(1) of Right to Information Act, Section 257 of Income Tax Act, where reference can be made. So therefore, there is a sixth jurisdiction, reference jurisdiction. Now, the seventh jurisdiction is review jurisdiction. Now, after dismissal of a bill, that is under Article 136 of the Indian Constitution. After dismissal of the SLP or a criminal appeal or a civil appeal or any case before the Honorable Supreme Court of India, then under Article 137, a review petition can be filed before the Honorable Supreme Court of India for reconsideration of a particular case. That is very important. What I want to share, that if the review petition is filed and there is a specific order under Order 10L of the Honorable Supreme Court rules of Supreme Court, will review its own judgment. Now, in the rules also of 2000 Supreme Court Rules 2013, in that rules also it is provided. When we file review petition, when people are filing review petition, then we have to give a certificate that no other petition has been filed except this petition when we are filing that review petition. Now, we are praying therein to reconsider our case if it has been dismissed or it is against, the order is against us for our clients. So whenever, but one thing is very important, that review petition will go before the honorable same judges who have decided the case earlier, if they are available. Meaning thereby means they have not been retired. Now they will deal again. They will reconsider your case. In some cases, Supreme Court review its own judgment. There are a number of judgments also. We are not sharing the judgments. Now, the last but not the least, the last jurisdiction is now curative jurisdiction. What is curative jurisdiction? The Supreme Court evolves its own jurisdiction, that is curative jurisdiction. Now, for example, SLP has been filed and it has been dismissed. Special petition has been filed and it has been dismissed. Now, subsequently, review has been dismissed. Can that order be challenged by filing a writ petition before the Honorable Supreme Court of India? Question arises here. If there is a defect which has not been pointed out in the which is not been considered in review, but there is still some defects which has been not been cured, then Supreme Court thought it fit in the case of Rupa Ashok Hurra versus Ashok Hurra, and Supreme Court decided, Honorable Supreme Court have decided that in some cases when there is after the consideration in the SLP or criminal appeal or civil appeal, it has been not been pointed out, or no person has been heard, or no opportunity was given which has not been pointed out. There are certain cases, or there are certain defects which have not been came to the notice of the Honorable Supreme Court of India. In that circumstances, curative petitions can be filed before the Honorable Supreme Court of India to cure their defects. Generally, in that curative petition, three senior most judges of the Honorable Supreme Court of India will consider the case, and the two judges who have decided their case earlier, they will decide the cases in the curative petition. But when the case was going of Rupa Ashok Hurra and Ashok versus Ashok Hurra, and then there was a question arose when that after review petition, everybody will file curative petition. Then there will be a floodgate. Then some senior have advanced the argument that there should be a certificate given by a senior describing the ratio laid down Rupa Ashok Hurra and Ashok Hurra, it fulfills that case. Then only you can file the curative petition. Now, if senior is not satisfied, senior designated senior here means designated senior by High Court or by the Honorable Supreme Court. If they think fit that this is the fit case where there is some where the parameters which has been laid down in Rupa Ashok Hurra and Ashok Hurra, that cases senior are giving the certificates to file curative petition, and then only the curative petition can be filed before the Honorable Supreme Court of India. If the certificate is not being given to the petitioner, if the senior declines to give the certificate, in that circumstances, the curative petition cannot be filed without a certificate of a senior counsel stating that the parameters which has been laid down in the Rupa Ashok Hurra, in that circumstances, then only curative petition can be filed. When we file curative petitions, we have to file 1 plus 5, 1 in original and 5 petitions, because it may go to 5 judges bench. So therefore, this is all about the jurisdiction of the Supreme Court of India, and it is very important to know if we are practicing in Supreme Court, what are the jurisdiction of the Supreme Court. When Supreme Court entertains the petitions under various jurisdiction, that is all about 8 jurisdictions of the Honorable Supreme Court of India, which I have dealt with. Now, I request Mr. Rajesh Singh sir.
Yes, Mr. Rajiv Kumar, it is very fantastic session by you. There are certain questions, sir, from the students. Sir, as already you have told that there are various jurisdictions, but generally what advocates in the Supreme Court do, they adopt 136. So why it is so? Because we have different jurisdiction, but still the advocates file the case in 136.
So, I will answer to the query that whenever there is a special jurisdiction, like in original jurisdiction, like in appellate jurisdiction, or in any other jurisdiction, then we have to file that case. For example, I want a transfer from one state to another state. Then I have to file under section 25 of CPC, which for civil cases, or under section 406 of CRPC. I cannot file under 136 because that jurisdiction specifically provided under original jurisdiction. That is 139A of the Indian Constitution. Indian Constitution. That is transfer of certain cases. Now, Supreme Court have the power to transfer the case from one state to another state. That power is vested with the Honorable. Therefore, where there is a specific provisions, then we have to file the case under the same provision. But if there is no provision and we are agreed by the order of the High Court or by any other order, which says there is something error, then we can directly come to Supreme Court under article. Therefore, I said, when I am describing the discretionary jurisdiction, we are filing special leave petition under article 136. But We cannot file a petition under Article 136 if there is a specific jurisdiction given under the statute or under the Indian Constitution. If there is any specific provisions are given, then we have to come under that provision only, or under provision under the Indian, under any article under Indian Constitution of India. We cannot come under Article 136. But when there is no such provision, there is no remedy after dismissal of the order from the High Court, then we come under Article 136. This is a specific answer to this question, sir.
Very well explained, sir. One another question was student have asked that if suppose the High Court will not issue a certificate under 134A, so what is the remedy available? So for example, there is a criminal matter and
right. Therefore, if certificate is not being given under Article 134A, I have or in original jurisdiction, I have explained in civil matters and criminal matters. But if the certificate is not given, then in that circumstances, you have to come under Article 136. You have to seek leave of the court, special leave petition file, special leave petition criminal. And if the court notices, and after the reply of the in criminal cases state government, then the Supreme Court may grant leave. Then it will convert to criminal appeal. That is a specific. Then in that circumstances, we have to come under Article 136 under discretionary jurisdiction of the Honorable Supreme Court of India.
Sir, one student have also asked one question that when the Honorable Supreme Court can take a suo motu with his own case, what are the conditions?
In suo motu, if there is any public interest, like in Lakhimpur case, we have seen the Supreme Court has taken suo motu to inquire about that case. The Honorable Supreme Court has taken suo motu, and the case is going on. I will not comment upon that. Now, in contempt also, as we have seen under contempt of court, under Article 129, the Supreme Court having its own power of contempt, then in that circumstances, the Supreme Court can suo motu contempt any person and issue notice to him and to say why there is no contempt against you. So therefore, under Article 129, we have seen contempt jurisdiction. So Supreme Court can issue contempt suo motu. And in public interest litigation, the Supreme Court can, in public, if it is in public interest, the Supreme Court can suo motu take the case, or Supreme Court can, like in we have seen the transfer of cases, Supreme Court will see two different high courts having different views. Then Supreme Court will transfer all the cases to the Supreme Court. We will decide, because there are conflicting views of the different high courts. So suo motu power is there. If there is any public interest, the Supreme Court thinks, we have to take a suo motu, then the Honorable Supreme Court definitely will take a call on that. It depends upon.
Sir, one last question. Sir, in the creative petition, there is a requirement of a senior designated advocate.
Right.
So if suppose a person who is a poor, who do not have a money, so how he will?
He can approach to legal aid service authorities. Every court having legal service authority. Legal aid.
So whether the legal aid authority will provide to
but the parameters which has been laid down in Rupa Ashok Khurra has to be, no senior will give. If the parameters, if you will not fall in the parameters, then definitely it will not. You can approach if the senior, because there are senior there also, we are on the panels, and they can give the certificates to them. You are right. The question is very right. The poor, the fees are very high of the senior counsels. So therefore, in that circumstances, a person is not offered, then he can approach to the legal aid, and he can, if his case satisfy the parameter laid down in Rupa Ashok Khurra, then in that circumstances, he will get that certificate from senior designated counsel.
Very well explained, sir. So this was the total 5 questions which we have put it from the student. Sir, it was a very fantastic session by you, and you have given a precious time to our university. It is a great pleasure to us, and we will also invite you physically at Vadodara on any day, sir, whenever there is a possibility, and we are very much highly obliged for this particular session, and it was a very marvelous and fabulous session, sir. thanks a lot for your kindness.
Thank you.
So
Rajesh.
we are closing this session. I'm thankful to Jiten Kubani sir for giving this live coverage. Jiten Kubani sir, are you there? So sir, we are closing this session.
Thank you, Rajesh sir, for giving me opportunity to speak on this subject. Thanks a lot.
Thanks a lot.
Thanks to Parallel Institute also. Thank you.
Thanks a lot, sir.